I'm Jason Lazarus, founder of Synergy, and I will be your host and MC today. Joining me as co-MC is Rod Santomauro, who's our Vice President of Strategic Partnerships here at Synergy. And the purpose of today is to give you more subject matter insights. So I want to welcome you to a part of our webinar series that features our subject matter experts. It's part of an ongoing series featuring our subject matter experts who give you thought leadership insights into the issues that impact personal injury recoveries. During the presentation today, which is a Q&A, to ask a question, use the chat feature, and the question will be read aloud and answered by one of our SMEs. And before getting started with the Q&A, I wanted to give you 30 seconds about Synergy. A trial lawyer or paralegal's job isn't to know all the nuances of the issues to be addressed when a case is over, to know what it takes to keep Medicaid in place or SSI, preserve Medicare and comply with the Medicare Secondary Repair Act, and resolve complicated liens that may be present when a personal injury matter is resolved. Liens like ERISA, Medicaid liens, Medicare Conditional payments, MAO plan liens, FEBA liens, all of these issues are things that the trial lawyer or paralegal really doesn't have the time or relevant expertise, knowledge to deal with. They need an expert strategic partner that they can rely upon that can handle it without question. And that is exactly what Synergy is. It's why thousands of top personal injury firms turn to and partner with Synergy every single day. So now that we've got the preliminaries dealt with, let me introduce you to our expert panel. First off is Ashley Wieland, who's a senior lien resolution specialist here at Synergy, where she spent the past 5 years helping attorneys and clients navigate complex healthcare lien issues, successfully negotiating thousands of liens and achieving more than $45 million in savings on behalf of the injured parties we serve. With several years of prior experience in subrogation, Ashley brings a deep understanding of reimbursement rights and negotiation strategy. Her primary focus is ERISA lien resolution, and her expertise, precision, and commitment to advocacy make her a trusted leader in the lien resolution space. Next up is Jasmine Patel, who's a lien resolution manager here at Synergy, where she spent the past 8 years resolving thousands of liens, securing over $25 million in client savings, and managing the lien resolution team. Her primary focus is traditional Medicare lien resolution with a strong emphasis on obtaining reductions through a Medicare refund process. Lastly is Kevin James. Kevin is a lien resolution attorney with Synergy, and prior to joining Synergy, he spent over 5 years with the Rawlings Company. He's got extensive experience handling multiple lien types, including ERISA, Medicare Advantage, Medicaid, and FEBA. So with this expert panel, with your questions, when you input them, we will address to each individual subject matter expert. And I'll get us rolling with a couple of questions here. First for starting with Ashley. So Ashley, what's the biggest challenge lawyers and paralegals typically face when resolving ERISA liens?
I want to say simply just getting the documentation that you need to appropriately determine the plan's rights. With vendor changes, company changes and everything, you may not even know the correct vendor. Whoever you were talking to last week about a Cigna plan might not be the correct vendor for a Cigna plan that you have this week. So even getting that initial lien process can take months. And then even once you have the lien, getting the appropriate plan documents, most of the time the vendors don't even have them. So you have to go to the employers. You have to find the right contact information for the employers. Most of these vendors will try to send you their little benefit booklet and act as though that's all that exists and it's got strong language, but you really need to make sure that you're getting all of those other documents, like the master plan document and the Form 5500 to truly verify those rights. And most of the time those documents are pretty difficult to obtain.
Thanks, Ashley. Next up, Kevin, with the resolution of Medicaid liens, since it does vary state to state, what are some of the common challenges faced regardless of state to state variance?
I would say the biggest thing with Medicaid liens is important to remember that even at the federal level, they are limited. There are limitations to what they can recover from, or what portion of the settlement they can recover from, and that is specifically medical expenses only. So in any state, the Medicaid program can only recover from that portion of the settlement funds that are intended to compensate for medical expenses. So they can't touch things. They're not supposed to be able to attach a lien to any kind of funds that were for pain and suffering, non-economic losses, those kind of things. So whenever you're doing an allocation of a settlement that has a Medicaid lien holder, you kind of want to see what you can do to allocate to things to other than medical expenses, because that is what Medicaid, across any Medicaid recovery program in any state, is limited to only medical expenses. So I would say that's probably the one thing that does run through all Medicaids.
Thanks, Kevin. Next up, Jasmine. The Medicare Secondary Payer Act is fairly complex. What are some common mistakes that are made when dealing with the Medicare Secondary Payer Act and resolving conditional payments?
Yeah, so I would say probably the biggest issue we see is clients relying on a conditional payment before they've actually received the final demand. So, a common thing we say is not to rely on that conditional payment. It is conditional. It can change at any point until settlement is submitted and a final demand's issued. So that's definitely a big mistake we see, where, a client will settle the case thinking that the conditional payment amount will be the final. And then when they go to report settlement to Medicare, Medicare adds on additional claims, and we have a much larger final demand to deal with. So there is a couple things I guess we would recommend for this. Medicare does have a final conditional payment process. This allows you to lock in an amount prior to settlement. That's definitely a process we recommend if you anticipate settling the case soon. But other than that, definitely don't recommend relying on that conditional payment amount until you've actually secured the final demand.
Excellent, Jasmine. This is Rod. I've got a follow-up for you, and then we have another question being typed in now. A lot of times we get questions regarding traditional Medicare versus Medicare Advantage. And I know that especially Rawlings is notorious for saying that they shouldn't be doing the pro rata reduction for Medicare Advantage. Can you talk about how under that Chapter 42 of the regs, how they should be availing themselves to the pro rata reduction for Medicare Advantage, because they are availing themselves to a lot of the same penalties, and how that should be fought for? Jasmine, that's for you.
Sorry, can you repeat that?
Sure. So regarding Medicare Advantage, a lot of times we get calls, especially with Rawlings, they won't go ahead and do the pro rata reduction versus traditional Medicare.
Right.
Can you talk about Chapter 42 of the regs for Medicare and how that can be done? Because Medicare Advantage does avail themselves to a lot of the same penalties as traditional Medicare, and
Right.
how we don't take no for an answer, and how that's fought for regarding those reductions.
Yeah, so definitely, Medicare Advantage has the same rights and responsibilities as traditional Medicare. So for a lot of these Medicare Advantage plans, we do see them reduce for fees and costs. Unfortunately, Rawlings is really the one lien holder that does fight us on that. But it does take persistence, and sometimes we have to get those escalated. But typically in the long run, we do get them to agree that, they have the same rights as traditional Medicare. Traditional Medicare reduces for fees and costs, so they have to as well.
Thank you.
All right, so we've got a question related to ERISA. ERISA, it's happening frequently where hospital bills PIP and then bills the exact same amount to health insurance, resulting in a double payment and then a lien for a huge amount. Are the health subro companies, Rawlings, et cetera, required to seek repayment, or does that fall to us, the attorneys? In past, I advised that PIP made payment and the specialist would go seek reimbursement for what they paid. However, in a more recent case, the case manager flat out refuses to do anything. Ashley?
Yeah, so I know when I was on the other side, I worked at Optum prior to my time at Synergy. And yes, it is the expectation that the subrogation vendor should be the one seeking that repayment or refund back from the provider, not, and it shouldn't be on you. The reason that these vendors refuse to do it is because it's a process that takes way longer than requiring you to hold up the settlement until you pay it. So if they refuse to do it and demand that you repay from the settlement funds and hold the funds in trust until the issue is addressed, then most of the time the attorneys would give in, getting them the issue resolved on their end faster than if they had to go to the provider. My go-to when I come across this situation, which I have several times, is to look at the overpayment section of the SPD and see what it says about who they can recover those overpayments from. Sometimes they say they can recover it from the member, but for the most part, I see it say that they have to recover it from the party that was overpaid, in this case being the hospital.
Thank you. So next question is, we have another Jasmine on the call. So Jasmine, you can answer this. Kevin, you can jump in. I think it applies almost to any lien type, but specifically the question is, with them being, I assume, the subrogation carrier, only being able to recover from medical expenses, are we able to dispute the Medicaid or Medicare lien if the final settlement is less or not much more than what we have the bills being? Feel free to respond to that. That's any one of you, but especially Jasmine or Kevin.
Yeah, I'll take that one. So if I understand the question correctly, it's kind of like when a situation where the case value was significantly more, or could be argued was significantly more than was actually recovered. And that is where the negotiation comes in about what, proportion of the settlement was intended for past medical expenses, or medical expenses in general. And that's usually where the negotiation is. Most states have a statutory calculation that is applied in these kind of situations about what they can recover, their maximum recovery. But that's often what we argue against on these Medicaid liens, is that's their maximum recovery. And obviously the entire settlement did not go to compensate just for medical expenses. So that's where sometimes the argumentation comes in. With Medicare, though, it's a little different. What I was referring to there was Medicaid. With Medicare, it's a little different. The Medicare Advantage plans are much more willing to reduce in a situation like that below a standard procurement cost reduction. And then Jasmine, on a traditional Medicare, they will take basically the statutory amount is they'll take basically the entire judgment minus your fees and costs. But that's not the end of the road, and I'm going to toss it to Jasmine on that part.
Yeah, thanks, Kevin. Yeah, so traditional Medicare, they will take all of the settlement after fees and costs if the conditional payment exceeds the settlement amount. However, there are, like Kevin was saying, some post-final demand options to request either a waiver or compromise. These are situations Medicare will look at, other things such as like the injured party's financial situation, hardships from the accident, those kinds of things. And they'll review all that information, and they will determine if the final demand should be reduced further. And in situations where there's limited settlement and a higher final demand, that's typically where we see the most success.
Thanks, guys. Next question is from Carly. And it's, how do you prove what portion of the settlement is allocated for medical versus pain and suffering? And I'm kind of assuming this is angling towards Medicaid. But if anyone who's asked a question, if we don't answer exactly what you would like for us, just put back in the chat a clarification of what you're looking for in terms of answers, and we'll try to address it. But with that, Kevin, do you want to take that?
I can kind of handle it if you want to do an assist on there. So I guess from a lien resolution, says, obviously 99% of these settlements are undifferentiated. Allocation and all that other kind of stuff. And really, this is where the negotiations come in. So like, obviously, if you have like a jury verdict or a judge or an arbitrator's allocation, obviously that's powerful evidence of what portion of the settlement went to where. But again, 99% of the time, we don't actually have that. So that's a lot of times where the negotiation piece comes in and all this and all these other things. And there is, the option to take it to a hearing where it gets a little bit more, again, you're trying to say or use facts in your case that would show that the settlement was not just for medical expenses only. And that's kind of how I would put it. It's more, again, it's where the negotiation point comes in more than anything for us is, there's a loss in consortium claim or whatever it was, or it's a global settlement or that kind of thing. I don't know, Jason, you want to add to that?
Well, so under Allborn, it's a pro rata equitable distribution type of argument where you're looking at the total value of damages compared to what was actually recovered, and then using that ratio to reduce each element of damages. So then that's typically opinion based on the non-economic damages. For example, here in Florida, we have a hearing process, and I handle those before the Division of Administrative Hearings, and I put on evidence as to the breakdown of each element of damages. But you could simply ask counsel to break down the damages based on their opinions, because if you read the case law out there, case law supports the idea that attorneys who do this for a living are uniquely positioned to evaluate the buckets of damages and allocate. And so you can use those arguments to ultimately back up the pro rata reduction kind of methodology if you're dealing with Medicaid liens, regardless of what part of the country you're in. Ultimately, some of that, the argument will be it's self-serving when you say a case is, $100 million damages case, which I've had recently where, there was an argument that minor child, that hypoxic brain injury, that you can argue with a straight face that particularly the non-economic damages for a child that will never live on its own, never get married, never have a family, what is the value of that? So, that is a way of dealing with those issues to some extent.
So I've got a couple things here. The first one, Dwayne, if you could please rephrase your chat. We have had a request reimbursement and the case manager refuses to confirm payment after sending them payment information. If you can expand on that, and we'll certainly circle back to you. Jason, some housekeeping here. These are great questions being posted in the chat. When this is over, will we be able to save the Q&A? And then Jason, when you're done with that, I can also follow up with the next question as well.
Well, the Q&A, I'm not positive that we can save it. This is being recorded, so all the questions and answers will be memorialized here in the recording, but I don't know if I can get the questions actually downloaded, but they will be memorialized in the recording itself.
Okay, thank you. And then for Jasmine, do you have an obligation to report a claim to a Medicare Advantage plan besides capital YES for yes? Can you please tell everybody what will happen if you don't do that?
Kevin, I think, is answering this one.
Sure. Sorry, Kevin.
Yeah, that's all right. So I'll take this one. So as Rod kind of hinted, yes, with one caveat. There is a circuit split with the Second Circuit on whether the plaintiff attorney and the patient are primary payers. However, the general answer for the rest of the country is yes, Medicare Advantage has essentially the same rights as recovery as traditional Medicare. So if the member, you do have an obligation to notify. They also do have access to all the penalty provisions that exist under under traditional Medicare rules, i.e. they can come after double damages for it, and they will sue everyone. They will sue you. They will sue your firm. They will sue the patient, the third party, all of these. Now, the caveat I mentioned in the Second Circuit is they did hold that in the Second Circuit that the plaintiff attorney himself and the patient are not what are considered primary payers. And that's what triggers the obligation to reimburse from Medicare. But they did hold the third party, even in the Second Circuit, is the primary payer. So what that tells them is there's a technical circuit split, but understand that those property casualty vendors are going to make you sign a release saying you're going to take care of the Medicare liens. So if they do sue the third party, they're just going to come back to you on the back end. Okay. So the general rule is yes, you do have an independent obligation as an attorney to notify Medicare when you if the person's Medicare eligible is actually the caveat. So at Synergy, when we talk about Medicare Advantage plans, our recommendation is yes, you do need to put these things on notice when you're aware of them when you have the opportunity and all that other good stuff. And remember, the trigger is whether the person was eligible for Medicare. That's why we sometimes refer to Medicare Advantage liens as hidden liens, because one of the mistakes that a lot of attorneys have made is they go to traditional Medicare. Traditional Medicare says, nope, there's no payments. And it's because there's a Medicare Advantage plan that was out there making the payments, and it can show up after settlement and all kinds of stuff. And it does carry those same penalty provisions just as if they were Medicare in almost all cases. So they are pretty unescapable on that level.
Well, a couple of points too, like if you don't see that there's very much treatment with Medicare on the conditional payment letter, but you know that there's been substantial treatment, that may clue you in, hey, they may have switched over to a Part C plan after being on traditional Medicare originally. So you got to be careful and make sure you do all your due diligence if that's the case, because it may be that's what's happened. Another thing, and maybe Kevin, you can talk a little bit about this. There are third-party vendors out there that are being assigned Medicare Advantage plan lien claims, and it's created a lot of litigation that's going on over the ability of the Advantage plans to recover in these scenarios.
Yeah, that's definitely been extensive, a lot of litigation on that. A lot of it is coming from, there's an entity called MSP Recovery that has gone around to a lot of attorneys in this space, where they've been, as Jason said, they've been assigned the Medicare Advantage plan, and they've been arguing that they're entitled to the billed charges, not the actual paid amount. I can tell you, in my opinion, that doesn't even fit with the way the statutory scheme works. But they will do things like send you they have sent like demand letters to some of Synergy's clients, basically saying like, you owe us $200,000, and if you don't pay us, it's double damage and it's $500,000. And you'll investigate and you'll find out they never paid anywhere close to $200,000. They paid about 30. And I personally called MSP Recovery out on this, and what's led them to do is in their lien notices, they're only including the billed amount. And one of the reasons they argue they're allowed to do this is because under a different statute, they did go around and sue first party carriers, like PIP coverage carriers, for the full billed charges that the Medicare Advantage plan paid that should have been paid originally by PIP. And it's been allowed by a number of courts, but eventually there was a global settlement. My argumentation on that is they're relying on a different statute that actually does say the billed amount. The procurement cost reduction that exists in the MSP Recovery Act actually says the reduction is off the paid amount. It says paid. It doesn't say charges or billed amount. So they have a flaw in their whole argument. However, that has not stopped them from going around and making all kinds of these grandiose claims. So that is a running problem right now.
So next up is a question for Ashley and perhaps Kevin too. It is our understanding that holding from sending the release for the third party can be a good tactic to help negotiate ERISA liens to argue that the claim won't settle unless they reduce. But in a case where you need to send back a release for the third party in order to trigger the first party claim, does this reduce the ability to negotiate ERISA? And is there a different way you can negotiate that ERISA lien even with sending back the release?
Yeah, I would say most of the ERISA liens that I end up negotiating do already have the releases finalized. We most often negotiate post-settlement. Holding back that release is not the only avenue of negotiations with an ERISA plan. I know the vendors like to say ERISA means 100% reimbursement, but it doesn't. You have to look at the plan language. You can try to identify if there are any arguments that way. I think hardship probably has equal or more sway over a lien holder than utilizing the settlement release needing to be signed. Things like that. There are many, many avenues to negotiate ERISA. They're just difficult to identify those arguments because you have to get those documents, like I mentioned.
Thank you, Ashley. Next question.
Rod, I just wanted to add to that.
I'm sorry, sure.
Like Ashley said, the fact that, remember, what the vendors are after is a check. So the fact that money is in your trust account gives you leverage because they have to get through you for you to, issue out a check. So always remember that when you're dealing with these ERISA vendors, they want the most money for the least amount of work possible. That is the goal. So you do have that leverage over them that they're not going to get paid until they've dealt with your issue, with you.
Thank you, Kevin. Jennifer has a question. Can Medicare claim entire hospitalizations as part of their lien if one code out of 20 matches the injury making the basis of the lawsuit? How do you counter this argument Medicare is making? And Jasmine, maybe you can briefly talk about bundled versus unbundled charges without giving away all of the secret sauce that we have.
Yes, no, definitely. This is very common with traditional Medicare. They do include like the whole hospitalization. When they additional payment letter, you'll often see one claim line has, it may be 20 ICD codes included in that. What Medicare argues is that the primary code, meaning that first code, if it's related, then that whole claim line cannot be disputed and they are able to be reimbursed for that. But synergy, as Rod mentioned, we do have some arguments here that we use regularly where, we dispute those charges. And our argument is that if any of those claims included in that large bundle are unrelated, we will dispute it. And we do have, like Rod said, some secret sauce, some case law we use to support that argument. It's not successful 100% of the time. It's typically a fight with Medicare. Like I said, their position is that as long as that primary code is related, it stays. But we do push back on that a lot, and we do have some success with it.
Thanks, Jasmine. Next question. CMS and other lien holders frequently attempt to claim that entire hospitalization is part of the lien, even though the specific injury that is the basis of the case is only a small part of the treatment rendered during the hospitalization. What's the best way to obtain a reduction of the entire hospital bill? And does your company provide this service? Questions from Patrick. I think part of that is in our service in terms of the reasonableness of hospital billing if we're talking about the hospital lien itself, but I'll leave it to the experts here to chime in.
Yeah, it sounds kind of similar to what I was talking about before with CMS, specifically claiming that one large hospitalization. Definitely that is a service. Disputing those claims, fighting those claims is part of our service with the traditional Medicare files, definitely.
Yeah, and then I'll add, as far as like hospitals and things like that, yes, there has been, it depends on what state you're in. Various states handle provider liens differently. So most of the time there's a statute, sometimes there's not, but a lot of times there's case law or the statute itself that limits the reasonableness of what a hospital can be, reasonable amount of a hospital can be. And it's in most states, just because a hospital's full bill charges, that doesn't automatically mean that that's a reasonable charge. That's been recognized in a number of jurisdictions, not all. But this is, we do have ways to try to figure out, how much it costs a hospital to provide the treatment. And so when we kind of do that analysis and then we see that their full bill charges are 16,000% markups, we can certainly argue against the reasonableness of those bills in that context. So there are arguments usually around reasonableness of charges to get those kind of things reduced among providers. But it's very jurisdiction specific of what that looks like.
Thank you, Kevin. Next from Shelley for Ashley. We will at times get a lien from an ERISA plan stating they can give us a small reduction, but if it is a true self-funded ERISA plan, there should not be a reduction at all, correct? What specific language should we look for in the plan docs to be sure it is a real self-funded plan that does not allow reductions? And Ashley, feel free to talk about the mysterious USC 1024 B4 statute in the notice letter and rack up those penalties for them not doing what they're supposed to.
Yes. So despite what, like I said, despite what most of these subrogation vendors will tell you, self-funded ERISA does not automatically equal 100% repayment. It all comes down to what is in those plan language documents. To determine funding, there is typically administrative section of the SPD, which would notate like who the plan administrator is. And most of the time there it'll note what type of funding the plan is, whether it's self-funded, level funded, or insured. And then the Form 5500 is another good resource to determine funding. As far as whether or not the plan has rights to reimbursement, you really have to tear apart that subrogation provision from the governing document, which is typically the master plan document, not even the summary plan description. The biggest ones you have to look for are made whole, first priority, and common fund doctrine, but that's not the only thing that you can leverage to try to get a reduction. There's things like contributory negligence that we could leverage. And then there's a whole lot of arguments that are in a gray space too that we often leverage and get reductions on ERISA plans.
Just to add to that, I think there's a piece of this, and I just want to make clear that we say this. Just because a health plan is an ERISA self-funded plan by itself does not automatically give them rights to 100% reimbursement. Their contract language has to have the provisions supporting that. And so a lot of the vendors, Rawlings does it, Optum, a lot of their people are not, they're trained to say it's ERISA self-funded, I'm entitled to full reimbursement. That's not the whole analysis. So just because they're ERISA and self-funded does not mean they have a right to reimbursement at all or 100% reimbursement. I just last week came across an ERISA self-funded file that had no reimbursement or subrogation language in it, and they were trying to assert a lien. Well, you don't have a right. You actually have to have the contractual provisions to assert a lien. So they will say things, I'm ERISA self-funded, full reimbursement. That's not the whole analysis, but they want you to believe it is.
Our next question is from Michael. Do attorney fees and costs always take priority over medical liens? I'll toss it to Jasmine first because that's a good one for Medicare, and then let the rest of the panel weigh in.
Yes, so for Medicare specifically, Medicare is always going to reduce for attorney's fees and costs. So when they're issuing the final demand, they will never issue a demand for the full settlement. Once you report your fees and costs, they may take the remainder after that amount, but they will always make that reduction. And I'll pass it to Ashley or Kevin to answer for the other lien holders.
Okay, I'll take it. So with Medicaid, I mean, this question really depends on what type of lien you're dealing with and then what jurisdiction you're in. So it's kind of a big question. So with Medicaid, some states, they do allow automatic reductions for fees and costs. Other states will allow for reduction of fees and costs, but it'll be for some lesser amount than whatever your contracted rate was. It'll be written into the statute. If you're dealing with a self-funded ERISA plan or a FEBA plan, they can, and most of them will write into their plan language that they do not have to reduce for your attorney's fees and costs. And they can do that under the McCutcheon, U.S. Supreme Court case of McCutcheon. So they will argue with you that they are not required to reduce for your fees and costs. Individual plans that are subject to state law is going to vary by what jurisdiction you're in. Some states are very clear that an attorney's fees and cost reduction is required. Others, it's not. One of the debates that we get into with lien holders sometimes is the common fund doctrine in a specific state will say the attorney is entitled to a reasonable fee. Well, I know most people think if I don't have to litigate, it reasonable is a third or 40% if I do have to litigate. Well, what these vendors will then try to argue is like, no, we think 10% is reasonable. Okay. So it's a bigger question. It's not a yes or no answer because it's going to depend on what kind of lien holder you're dealing with, what jurisdiction you're in. Again, like we talked about with the ERISA self-funded files, they actually have to have the language disavowing the common fund doctrine or saying they won't reduce for attorney's fees. There are individual states out there that also state that if a plan language disavows paying of attorney's fees, that's allowable in those states. So it's a large question, depends on a lot of things, I guess is my answer. I don't know, Ashley, if you want to add to that.
No, I mean, like you said, you covered it. If it's an ERISA plan, you just look at that plan language. I would say 95% of the plan documents do either give first priority rights. So that would be a right over attorney's fees or defeat the common fund doctrine. So it can be difficult, and pretty much all ERISA lien collectors will tell you that their lien is of a higher priority than the attorney's fees. You just have to get that document to verify.
Thank you, Ashley. Kevin, I heard that before a case is filed in court, there's no obligation to notify Medicare about the case and/or settlement. Is that accurate?
Maybe in some states somewhere, but not most of them. So most states, every state has a third-party liability recovery statute. Okay, that this scheme is required by federal law, that the state have some scheme for third-party liability recovery. In each state, there will be a notice of what the duties are of an attorney to put the program on notice. Now, some of them do say, like, if a third-party action is filed, we have to put them on notice. That's when you put them on. That's when you have a duty to notify. That might be true. To me, you're gonna have to note the beneficiary is gonna have a duty to notify somewhere in there. Now, if you have a case that ends up going to litigation and that's when you notify Medicaid, I'm not sure that that will necessarily impact your case at all, that Medicaid will raise some issue that you waited until you actually filed. But a lot of times what happens is the duty to notify in most states actually arises when the member accepts benefits, right? That's when Medicaid's lien attaches, is when they make the payment for the member's benefits. And again, with this, it's a very specific in state law about when to notify and how you have to notify. The only state, there is a case out of California, and again, I don't know what state you're from, but there is a case out of California that where the duty to notify did not extend to the attorney in California. It's a lower level court opinion. I personally, if it was me, would notify Medicaid if I suspect Medicaid's involved in the case, because what can happen is almost all states have some type of penalty provision for trying to kind of avoid paying a Medicaid lien. And those penalties can range from making you individually responsible for paying the lien to it can be a criminal charge in Texas. Okay. So Medicaid is really not a organization that you want to spend too much time challenging as far as like the duty to notify and all those other kind of things. So when you do it is less important than that you do it at some point, I would say.
Thanks, Kevin. So we only have 5 more minutes left, so we will likely not get to all of the questions that remain because there's still quite a few. If your question was not answered, we will send you an email directly with some thoughts related to your question. So don't worry, we didn't get to you. We will address those to you in written form. So this next one is from Stephanie. An ERISA plan is asserting a reimbursement claim against my first party settlement. Is there any way to dispute this so the recovery is limited to the third party settlement only?
Yeah, so again, you have to look at the plan documents. Some circuits, actually, you don't have to call it out. And so you have to look at what the relevant case law says. But most of the time, you have to look at that subrogation provision. And if it calls out first party, that they have a right to first party settlements, or they have a right to settlements from UIM, there really isn't a way to dispute that. I would just recommend verifying that, and then you can try to leverage it with acknowledging the fact that the plan has a right to it, but the fact that it is the injured party's own insurance, and leverage that in the hardships and try to get some form of reduction on the table.
Okay, everybody, we're gonna squeeze in one more because we want to be cognizant of the time. We have a situation here where we're being asked by Shelley, what can we do if we send a letter of rep certified requesting lien info to Medicare, Medicare Advantage plans, and Medicaid, and they don't respond within 30 days from the date of receipt? My attorneys say since it is the government, we have to keep trying. Jasmine and or Kevin, and then Ashley, time permitting, if you wanted to chime in on private liens like self-funded ERISA, feel free to do that.
Yes, so definitely just speaking about the traditional Medicare files, if you send a letter of rep, you should get a response from them. If you don't within 30 days, that's not cause for you to just disregard that. It was definitely something you'd have to reach back out to CMS for, specifically with CMS files. Once settlements reach, defense reports settlement via Section 111 reporting. So, you know, in situations where maybe you didn't report a case to Medicare, they will eventually find out about a case in settlement from defense, and they will issue a final demand at that time. So again, it's not typical for Medicare, I guess, not to respond to a letter of rep and open a file, but if they, for whatever reason, do not, I would definitely reach back out to make sure that gets opened.
Thank you, Jasmine. Anything to add, Ashley or Kevin?
Yeah, I will say with Medicaid plans, again, it's going to go back to your state statute, but the vast majority, if you send Medicaid program a deadline letter, they're not obligated to pay any attention to it. Most of the time they have, depending on the state, they might have a statutory time frame they have to respond. And usually it doesn't wipe out the lien, even if there is a statutory issue there. It basically maybe sets some presumptions that get made as you move through the case. But most Medicaid programs have a statute in there where the lien's valid until Medicaid says it's not. It's not closed until they say it's not. So if they're not responding, you don't really have a lot of recourse. Some states have written into their statutes that it can be different. ERISA plans, again, it's a whole other ball of wax. Or private health insurance plans. Some states have rules about this, most don't. So I'll kick it over to Ashley though on the ERISA stuff.
Yeah, not a lot to add. I mean, ERISA plans, to my knowledge, there's not really a lot out there that requires them to respond by a certain date. And I can tell you, most of the time, you're not going to get a lien within 30 days, particularly with some of the changes that the vendors are making. We're seeing delays across the board for most of them. I know with Optum, if you ask them for a lien at one point last year, they were at about a year for an unsettled case. I waited for a lien, and we called every couple weeks to find out, and we're just told that it's still processing, and there was really nothing we could do. Our hands were completely tied. It's incredibly frustrating, and I can acknowledge that. I really wish that there was more, but all you can do is just stay persistent, and that's what we're here for.
So to finish this up, Rod, I want to direct a question to you. How can law firms benefit from partnering with experts like Synergy when it comes to these difficult lien resolution questions?
Well, I think there's three takeaways from that for everybody on the call. Number one, we're always happy to do a complimentary consult, myself included, and all of our subject matter experts. So if you have a question on something, we're happy to address it, let you know whether or not we can help, and you won't get a bill from us. Number two, just remember, if you don't know already, that the only mathematical result when we get retained is a net gain to the client. We have a reduced cap contingency. So when we're hired, our success is dependent on how much we get the lien reduced, and we cap it. So the only end result on any lien when we get retained is a net gain to the client, bar none. Number three, finally, we have just under 100 people at Synergy. Many of them worked at Rawlings, Conduit, Optum, all those places. We have 40 plus experts that were either defense subrogation attorneys or veteran adjusters. We have experts that handle every single lien type and have years of experience. So respectfully, we're going to get better results than any law firm could or any other company would based on the bandwidth we have at Synergy. You can follow me on LinkedIn. I've got about 17,000 plaintiff trial lawyers. I'm happy to add you and share in the networking that I have there. And you can also feel free to email me there with any follow-up. Thanks, Jason.
Well, and to add on to that, what you saw today was answers from three of our top and best subject matter experts. We've got many more that are part of our incredible, we call them Subrobusters team, and their mission every day is to beat down lien holders and deal with the complexities and, frankly, the administrative burdens instead of you and your law firm having to deal with those. So that's another great reason why ultimately you should consider having someone on your bench or making Synergy your outsourced lien resolution department within your law firm when you're facing these difficult questions. And with that, thank you everybody for joining us today. Thank you for all the great questions, and keep a lookout for Synergy's next webinar just like this that'll share subject matter expertise. Bye everyone.